All right. So let me take a moment and welcome you. And Jennifer Nixon is our attorney that will be presenting tonight for our conversations and coffee. I don't know that any of us have coffee, but maybe Pat Butler, you do.
I have fruit.
Oh, good plan. Good plan. I didn't bring any coffee because I can't drink it this late at night. But but at any rate, we'd love to hear. Jennifer promised to share some information about potential processes or ways, strategies. And I'd love to hear what you have to share with us. So do you want to take it away? Jennifer's in a new law firm. Tell me the name of it, Jennifer.
Sure. So it's Henningson Snoxell.
Okay, perfect.
I think it's a rule that if you own a firm, you have to have a funny name. So.
I see. Well, congratulations on the move. And I've updated the website and everything so that everybody has the correct information. And we are delighted to have you here tonight.
Sure. And I did put together, I'm a PowerPoint person. I'm weird like that, but it would, and I can breeze through it because I know that you wanted to keep this fairly short.
Sure. Should I give you the host? So you can,
or could you make it able so that I can share my screen and then I can just share what it looks like?
To do that, I make you the host and then you can share your screen.
Oh, okay. That works.
All right. You're on.
Okay. Okay. Let me get it in the right spot here. Oh, that's not what I want to do. Maybe it is. Okay, maybe I don't know how to share.
Oh, down at the bottom, the green button says share. There we go.
Oh, there we go. Okay.
Okay.
I have to start
perfect.
It.
All right.
Okay.
Thank you.
Yeah. So, Patricia, you just shared that I did just started a new firm here in October. So I'm with Henningson Snoxell in Maple Grove. I do practice exclusively family law, both traditional and like the court-based process, and also collaborative practice. So I'll run through kind of what that means too.
Okay.
And just to talk super briefly about some process, this is kind of the process to go through the divorce. And there's somebody that says that they're in the waiting room. Should I let them in? Are you able to see that?
Yes, please. Can you?
Yeah.
Now that you're the host, you have to let them in.
Okay. I didn't know if you could see it then too, or.
Nope, I can't. Okay, here comes Deidre. Good.
Okay.
All right.
So really briefly, the summons and petition, the paperwork would need to be served first. And then we go through some forms of either alternative dispute resolution, try to negotiate. The default is going to a trial, but ultimately we're working towards a judgment and decree. So that's the document that that gets you divorced.
Okay.
And I was going to talk through just a few process options: mediation, which a lot of people do talk about, early neutral evaluation, which is similar to mediation, just negotiating, and then collaborative, and that default would be a trial. Okay. So in a mediation process, we have the mediator, who is a third party who has been trained in conflict resolution. Oh no, I'm back too far. Okay. Who's been trained in conflict resolution. They don't make decisions for the parties, but they do help them to reach an agreement. And so that's the role of that mediator. They don't give legal advice, even if they're an attorney. And so I almost always go to mediation with my clients, so that if there's any questions, I can answer them right then, and they can have that legal advice. And so that's something to keep in mind if you were representing yourself, is that going through that mediation process, you wouldn't, if you were representing yourself, you wouldn't have that legal advice there. Okay. And there's definitely some pros and cons. It is something that you feel like you have a lot of control over, because you still make the decisions. However, it is a voluntary process, and so that tends to lead to people sticking to their agreements. But it also is something that might not be the best if there is any kind of domestic violence or coercive control. Because it is voluntary, you can't force anybody to act or to reach an agreement. And so some of those things can be a negative. Okay. And then the early neutral evaluation is very similar. This is something that is court ordered. The evaluator is like a mediator, in that they don't make decisions for the parties. They help them to reach an agreement, but they actually evaluate the case and they say, this is what I think a court would do. Again, I usually go to this with my clients because then they can have that legal advice there, answer any questions. And there's two types. We've got social early neutral and financial early neutral. So financial obviously would cover the financial aspects. So property division and spousal maintenance and child support. And then social early neutral would be if a couple has minor kids. And so that would be custody and parenting time. Okay. Again, some pros and cons here. So like mediation, it is something that is voluntary. It is also a, you can't go into court later and say, well, when we were at the early neutral evaluation or when we were at the mediation, you were willing to do this. That's not something that you can do. And so both the mediation and that early neutral evaluation, that's really a benefit. But again, some cons, very similar to the mediation. If there's coercive control or domestic violence, that might be really difficult. It might be difficult to negotiate in that situation. Also, because it is also a voluntary process. You can't force anybody to come to an agreement or force somebody to act.
Jennifer, before you continue, Deidre, would you mute your microphone? We're getting some feedback.
Sure. Sorry.
Okay, no problem. I just wanted to stop it while we're hearing Jennifer talk, and then we'd love to hear from you later. Okay. All right, Jennifer, thank you.
Okay. So then there's negotiation. So this could be, so it says kitchen table approach, right? Where the couple sits down together and just kind of talks through some different ideas, tries to come to an agreement. This negotiation can also go through attorneys. So attorney mediated settlement. And then it's just a matter of drafting the documents. That kitchen table approach, somebody was maybe representing themselves. Then it's looking for the court forms, making sure that those are filled out, mediating or negotiating, I should say, through attorneys. Then the attorneys would draft that paperwork. Okay. Definitely some pros here too, especially in that kitchen table approach. You really feel like you have that control. You are still reaching an agreement in any of these situations, and so it's more likely that that you and your spouse are going to continue to stick to that. But again, some cons, just like that mediation, early neutral evaluation, especially because there wouldn't be a third party there in that kitchen table, at least. That coercive control and domestic violence, again, might make this process very difficult. Might make it might not make it appropriate. With attorneys, that can be much better. So if it was that attorney mediated settlement, but okay. And then there's the collaborative process. So collaborative is something outside of the court-based process. And the big difference between the collaborative and that court-based process, there's kind of two big ones. One is that it is more of a team-based approach. So it brings in a child specialist or a family specialist who really knows a lot about child development. It also brings in a coach, if a coach might be helpful, who can help with more the if there's communication issues or more the emotional aspects. And then there's also bringing in a financial neutral. So again, having that expertise from that financial person who is neutral in the case, who's not representing one party or the other. And then the attorneys are there to of course, to give that legal advice. The other big difference between this and more of a court-based process is that the process itself is completely out of the court system. So the agreements are reached outside of the court system. The documents that we draft are they're the same as it would be in a court-based process. But it's just it's a different way to get there. So the court still reviews it, still signs off on it. So you've still got like that teeth of the court if you need it. Okay. Also some benefits here. So you really get that expertise from those neutrals. So the child specialist, for example, like I said, knows a lot more about child development and could even talk to your specific kids. And so that could be very helpful. that financial person is going to be able to give some financial advice from a very different perspective than even an attorney would. And so that can be really helpful. Also, not going to court and knowing that you're not going to go to court, the negotiations feel very different because you know that you are going to resolve it through this process. So you can be a lot more open. But also some cons. So I said some of the other processes as well. If there is domestic violence or coercive control, I also see if there is some significant chemical dependency or mental health issues. I don't think that collaborative is the best fit. Now that that's a little bit my personal preference. There's a lot of collaborative practitioners that will do cases with that mental illness or chemical dependency, so long as there's a good coach on board. Personally, for myself, I don't think that it is the best process. And there some other cons to, it is voluntary, which can be a good thing, but also can lead to, it only moves as quickly as the spouse is moving the slowest. And so that can be frustrating. Okay. And then we have trial, very last resort. This is if the parties really just can't reach an agreement. And this could be just maybe on one or two issues. It could be on all of the issues. Generally, I see it's just on one or two issues. Usually there's quite a few that you're able to agree on. And it feels very attorney driven, which can definitely be a negative. I'll talk about some pros and cons, but that can definitely be a negative because you feel a little bit more out of control and you're not in control of that resolution either. Again, if you are representing yourself and looking at a trial, you wouldn't have that legal advice because you would be expected to act as the attorney. So you would need to know the rules of evidence, keep track of deadlines, make sure that exhibits are entered in the correct way, for example. And so that can be very frustrating and can be very overwhelming. Okay, so that's some of the cons, kind of talk through that. But it definitely does resolve everything. So if it's just you just can't reach an agreement, this will get you there. You're not kind of just left hanging out there. You will be able to finish the divorce if you go through a trial. It also can set some deadlines, which can be very helpful. I talked about that the other processes are voluntary, and so that can be frustrating. As far as moving the case forward, looking at a trial, that definitely wouldn't happen. The court wants to make sure that the case is continuing to move as fast as the court calendar will allow, but they will make sure that it's continuing to move forward. Okay. That's all I got.
Okay,
I think I may have talked fast enough.
perfect. So
So I have some questions.
well, good.
Well, when you were talking about the model where there's a mediator or an evaluator, who pays for them?
Typically, it's split equally between the parties. And I think that varies. I know you're in Canada, so I think that definitely varies depending on where you're at. But I know that in Minnesota, it is typically split equally between the parties, but it kind of depends on the case too. I've had some parties that they are planning to use like one specific credit card for divorce costs or one specific bank account, and so they agree on that's what they're going to use, and so then it's it's essentially shared, but that's typically the way that it's paid.
Okay. And then if suppose money is really an issue and people are really trying to, I've seen these books in a bookstore, Divorce for Dummies, right? If someone is really trying to do things and avoid attorney costs as much as possible, which model would that be?
So that would be more like that kitchen table type approach. So just maybe negotiating with their spouse. And then there are books like that. There's also, I know in Minnesota, we have a lot of court forms, depending on the county. There's some great self-help centers. So they can help to make sure that at least the right forms are filled out. Again, they don't give legal advice. But that can be helpful, at least to make sure that that like I said, the right forms are filled out and things.
Okay.
So Pat, is that kind of service available in Canada where people have help centers that would help with paperwork and stuff?
I have no idea.
Oh, okay.
All I can speak to is my own situation, which hearkening back, somehow we ended up with 2 female lawyers, and the woman who was doing our financial, coming up with our financial disclosure thing. We had
Mhm.
one woman who did for both of us, which was very, I think, cost saving, because we weren't arguing with each other about money at all. It was all very straightforward. We'd been married, Jennifer, 41 years.
Oh, wow. Mhm.
Yeah, a long time.
Mhm.
So anyway, so on the day that we actually sort of met across the table from each other in my lawyer's office, there was my ex surrounded by 4 women, which I loved. I thought, this is really cool. You think you're such a smarty pants, and we're the ones with all the. Anyway, so no, I haven't heard. My divorce happened in 2010, Jennifer. So it's actually a long, long time ago, and I'm not up to speed on what is available for people trying to save money around here. But the other one more question I have, it sounds to me, the very word going to trial, meeting you in court, that sounds long. Like it sounds like it's months away or years away. Like, aren't the courts absolutely chock-a-block?
Yeah, I mean, if somebody was to get to that point where they're going to trial, I mean, it's typically like a year from the beginning of the case. I mean, it's
Yeah.
a ways out or more. I've had cases where we just keep trying to settle because you have the control over it if you settle, and
Yes.
so what's going to happen. You're not leaving it up to the stranger in the black robe.
Yes.
But then the trial date kind of keeps getting moved, or
Yes.
maybe we don't set a trial date until later, and so that ending sometimes can feel far away. But yeah, the going to trial is the longest process, I would say.
Yeah.
For sure.
So that would be in your pros and cons, which you did for each situation. That would be a pretty big con for people who are anxious to get it over with.
Yes, definitely. That definitely is a big con.
Mhm.
Okay. Those were good questions, Pat. Thank you.
Good. You're
Yeah.
welcome.
Thank you.
You're
Okay, well, we just lost our other gal, Deidre. Oh, that's too bad.
Oh,
I was hoping that she would have some questions. So,
oh.
okay.
Well,
Well,
I just would like to, while we were talking about length of time, my husband, Jennifer, told me that the marriage was over. He took up with another woman, in January of 10, January the 11th it was. And we signed our separation agreement on the 5th of, or the 11th of May. So
Okay.
that's
wow.
5 months. So
Mhm.
that's pretty darn fast. And I found it enormously helpful. I was very unhappy at the beginning, but you do reach a point, especially when you start to think about, with him saying to me, so are you going to buy me out? Do you want to stay in the house? And initially, I just adored my house. It was the nicest house I'd ever lived in my whole life. And I said, yeah, I'm going to buy you out. Well, then when I started looking at how much it was going to cost and how the restrictions it would put on the rest of my lifestyle, I thought, no, this is not such a good idea. So those are the kind of things that, like, once you get your head around it, and of course it varies with personalities. Like, do you find some of your clients just dig in and they're so mad at their spouse that they want to make life miserable for them?
Occasionally, I do see more that, even if they're very upset at the beginning,
Yeah.
that a lot of the times they do kind of come to terms through the process. I always say that my favorite part of doing divorces is to be able to call and say the judge signed it. It's over. You know, that's always my favorite. I love to make that phone call because it is usually such a relief, and it is usually a very happy phone call. I mean, I can remember one case in my 11 years of practice that that somebody was not happy. That was not a happy phone call. He didn't want the divorce, and so that was not a happy time. But for everybody else, it's very happy. So so yeah, I mean, sometimes I see people that are kind of dig their heels in, as you say, and maybe not consciously thinking, you know, I just don't want this to be done. But I see that too. So I can see both sides.
Perfect. Well, Deidre, welcome back. We thought we'd lost you, so we're glad you're back. Do you have any questions?
I do. Can you hear me?
Oh, we can definitely hear you now. We are recording, so if you would like, I can turn the recording off if that's more comfortable.
I don't care.
Okay. Okay. Well, I just wanted to check. So
yeah, I appreciate your thoughtfulness on that whole issue. Yeah, wondering about what your advice would be. I've been through the collaborative process with my spouse. We have attempted to do an early financial neutral outside of court, and then a regular mediator, and we're going to try one more time with people that aren't even in the, you know, whole system, to some friends. And what happens is that we keep on making agreements, and frankly, my spouse keeps changing his mind. And so it's become exasperating. I'm just wondering what you would recommend for a situation like that.
Yeah, so typically when I go to a mediation, now I don't do that as often in collaborative, but if I go to a mediation, we usually try to sign something at the end and say, this is our agreement, and we are intending this to be a binding agreement. And so nobody can back out of it. Now, I don't do that so much with collaborative. So if you're still in the collaborative process, then that would be a little bit unique. But I've talked about doing that in collaborative cases because we don't want that to happen. You know, we don't want people to change their mind and have to start from scratch. So, so that's what I would do. Find something.
Right. Okay. So then my collaborative lawyer, she said, you know, this just isn't working with your spouse.
Oh, you're muted.
Okay. Can you hear me now?
Yep.
Okay. So she said that she said, I need to fire myself because this isn't working with your spouse. You need to go the litigation route.
Mm-hmm.
And that seems very overwhelming to me.
Mm-hmm.
First off, trying to find a litigation lawyer that I can connect with, that I feel I can, well, trust, right? I think that's a big issue. And then someone that can handle the tipsy-turviness of my spouse. You said earlier that you wouldn't recommend the collaborative process for mental health.
Mm-hmm.
And I never even really thought about that. And frankly, he deals with a lot of paranoia and a lot of other things that we can't pinpoint and that he's not willing to get help for. So it's made the process brutal.
Yeah.
So what would you do? I mean, if this was your case?
Yeah. So, I mean, it's hard to say, right, if it's time to leave the collaborative process. That's very rare. And so I'm always disappointed when I hear that a case has fallen out of the process, because it can work really well. And it is overwhelming, right? It's overwhelming. You feel like you're kind of starting over. I know I have taken over collaborative cases, though, if this makes you feel any better. I've taken over collaborative cases that moved to litigation, and they didn't completely start over because you've done a lot of work to get there already. So if that makes you feel, if that makes it feel a little bit less overwhelming, you've done a lot of like the financial disclosure already. The case that I had that fell out of collaborative, we had one early neutral evaluation session and we settled it. So it ended up being fairly streamlined because there had been so much work done. if that
Yeah.
helps, but.
That's helpful. And so this is one of my issues, is that we did it 100% collaborative. So I did not serve petition or summons or anything like that. So there's not like any county documents that prove we're even going through a divorce. So my concern is that we had set, the division of property as to be like May, and I moved out of the house. And now if we start a litigation, I'm thinking that we have to reevaluate the worth of everything. Is that true, or is that somewhat the case or somewhat not the case?
So not necessarily. So even in a court-based process, you, and I should say kind of in general, because, I don't know your case completely, but kind of in general, even in a court-based process, you can agree on a valuation date. So typically it's the first hearing, or what's called an initial case management conference. Some counties, kind of more outstate, use the pretrial hearing. So it's a little bit later in the case. And they use that as the valuation date. So that's the date that they kind of take a snapshot of everything and say, okay, this is what everything's worth on this date. You can agree to use a different date though. So I've had cases where even in the court-based process, we have an ICMC date, but they've been separated for 2 years. And so it doesn't make sense to use that date. They want to use the date back from when they separated. So as long as they can agree on that, they can use that. Or if you can show the court that this date makes a lot more sense and here's why, then the court can make that change too. So. Okay.
Right. Because I know that my spouse won't agree, because that's just the nature of the beast, the nature of the problem. But what you're saying is, even if we didn't agree, I could maybe prove, hey, we've been separated from this point in time. I've been paying this and this, he's been paying that. So essentially we've been, having separate finances.
Yeah.
Okay.
Yeah. And
Yeah.
you said that there isn't any documents, right? You didn't do the summons and petition. You should have done a joint petition though in collaborative.
No, we didn't.
Okay. Then that would need to be done at some point. So the summons and petition would just have to be done then at some point.
So can you do a joint petition without doing the summons? Like, I literally went downtown last week and tried to do all the paperwork for myself to see what it would be like to represent myself.
Mhm.
And with that, you have to serve the petition with, with a whole entire, 10, 20 page document of what your assets are and what you want to divide them.
Mhm.
I think that's the summons, right?
So that's probably the petition. I'm not as familiar with the court forms, but I know that their petition is a lot more detailed. Like when I'm drafting a petition, it's very general. And so it says things like the parties have various bank accounts. It's very general so that we can kind of fill in the detail as we get it. I know that the court forms tend to be a lot more detailed. They want you to fill in like, here's what my bank accounts are.
Right.
So that's probably the petition.
Right.
And then the summons has like restraining provisions, and then you list in there that if there's any real estate, so you list any real estate, and then it has those restraining provisions. So not changing any health insurance or life insurance, or I lump car insurance in there, kind of keep things status quo as far as insurance goes. Not dissipating any assets, so not spending money in the way that you would normally, and then not to harass each other. Those are all in that summons.
Okay, so a joint summons can be completed without having the petition.
So the joint petition, you mean? So the joint there's not a joint summons, it's a joint petition. And so I think that might be what you're thinking of. And a joint petition is that's something that you both sign. We typically do that in a collaborative case where we start with, it's kind of a combination of the summons and petition in one. And that's what technically starts the legal process, is once you sign that joint petition. But that's something that, yeah, you would need to agree on, like the language in there. And so those are really
Right.
even more general, because you're signing them together. So
Exactly. Yeah.
Okay.
This is helpful to hear, because all the language, I get lost in the language. I don't know
yeah.
anybody else.
Oh, yeah. Yeah, you can definitely get lost in the language.
Yeah.
Right.
Yeah. It sounds like you've done a lot of work on this, Deidre. Just-
Yeah, yeah.
Well, good. How best can we support you?
That's a really good question. If I wanted, to get the ball rolling without having to do a joint petition summons, then I could do one on my own. Is that correct? But
Yep,
either
so you-
on my own, I represent myself, or I do one with a lawyer.
So you can do a petition on your own. Yep. And so you would do a summons and petition. And you can do that on your own. You could also do that on your own and then decide, hey, I want to have an attorney. You could do that to get it started and then look for an attorney, or you could just represent yourself through the whole thing. So, just because you start with it without an attorney doesn't mean that you can't hire one in the future.
Okay, and like you said, if I start one without an attorney, am I bound to that petition? Can I go, oh, I don't think that I want to do that anymore. I'd rather do this? How
So
binding?
that's- Yeah, so that's tough. It's tough to kind of go backwards. So for example, like if you have minor kids, or a party that has minor kids, sometimes they'll get a petition that says that the other party wants sole physical and sole legal custody. And that sounds really scary. But the reason why sometimes that will be in there is because that, maybe it's a long shot, but it's hard to go backwards. Like it would be hard for them to say, okay, I want joint physical custody, and then go and get into negotiations and say, oh no, now I want sole physical custody.
Exactly. That's what I was thinking about. So like I said, I went downtown and I did what I could to figure out all these forms and fill this out. Look, it literally took 2 days to fill it all out. But I was very much halfway, meeting him halfway on everything. And I realized, I thought about that later, like if I set that precedent as halfway, then where do I negotiate to?
Mm-hmm.
I've
Right.
already put on the table what I want to negotiate to, versus starting, like you said, if I say, hey, I want everything, I want all the assets and everything, well, then of course there's somewhere to start from and negotiate to.
Mm-hmm. Mm-hmm.
Yeah.
Yeah.
So,
And I don't typically put like what assets I want or what assets my client wants in the petition, just because I want that flexibility. I want that flexibility to negotiate.
exactly.
So, and I think the court forms make you do that. So.
Yeah, I did very specific everything, and I'm thinking maybe that's not such a good idea. I haven't served it, so it's not, binding yet, right? And so this is got like a week or so to kind of figure this out. We're meeting with a couple of friends, and it would be lovely if all of a sudden my spouse says, okay, I can agree to what we already have in place. But the track record tells me that I'm kind of insane to think that all of a sudden, magically, it will work out.
Yeah. I've been surprised though.
Yeah.
I'm always optimistic.
I'll be very frank. I would really think it'd be a miracle. And I don't mean that in a mean way. I just mean that in a, hey, if God showed up in a huge way and decided to orchestrate it so that my spouse would sign it, I would be dancing in the streets. No joke. But I also keep in mind that that's not how it's been. So
Sure.
reality, right? There's reality. There's what I hope for, dream for, pray for, but then there's reality too.
Yeah.
So,
Yeah, definitely. And I think we have all been there in
Yeah.
terms of there is reality too. So, well, Deidre, we do have Jennifer as one of our attorneys that, you can certainly connect with. And then we also have another gal that is an attorney on our website. So feel free to reach out see who fits for you, and, if they can help.
Yeah.
Get a hold of them. Okay.
And that's Jennifer Beckman, right?
Right. Mm-hmm.
Okay. So I know
Yeah.
Jennifer Beckman well too, and she also does both collaborative and litigation. So I think somebody who does both and kind of understands the collaborative process would be beneficial for you. So.
right.
Yeah.
That's a good point.
Yeah.
Who does? I hadn't thought about that.
Yeah.
Because
Yeah.
lawyer 4 only does collaborative. And the one that was recommended that I met with last week only does litigation.
Mhm.
And I know
would
why,
agree. Yeah, that you need somebody who knows both.
right, so they understand what I've been through and
Mhm.
yeah, yeah,
And there's a lot of us out there, like you said, you need to find somebody that you trust. I think that's the
Right.
most important.
yeah,
So.
exactly.
Okay. Any other questions? Anything come up for you, Pat, in this conversation?
No, just gratitude that mine's all over. Deirdre,
Yes, and we all get there, don't we?
I was married 41 years, and my husband took up with another woman in November of 09 and pulled the plug in January of 10.
Okay.
So and then I found a fabulous new husband online and married again, and so I have much to be thankful for, and there is a light at the end of the tunnel. That's what I would like. My message to you would be, there
Yeah.
is. You probably have dark days when you say, "Oh my God, when is this
Right.
ever going to end?"
Oh, totally.
Let me tell you, it will end. And reach out to anybody who has words of wisdom to share,
Right.
because
Thank
there are
you.
lots of us who've been there.
Right. Yep. That's the good
You
news.
bet.
Don't have to do it alone.
You don't have to do it alone.
So this past week, I am packing up my things, going through things because I'm moving from Minnesota to Florida to live. Okay. And not that I'm happy about it. I like Minnesota, but for personal reasons, I need to go and stay there for a while. But what I did is I found my certificate of marriage, okay, in the cedar chest, along with my divorce decree. I'm quite, oh my God, I still have these things.
Right.
So I don't have them anymore. I gave the marriage certificate to my daughter and I threw out the divorce decree.
Oh.
Wow.
So I don't know if that was a wise decision or not, but for God's sakes, it's been since 1985 since I've been divorced. So I don't think I need it. But anyhow, we all have a journey.
Yeah, that's true.
Yeah, so, well, perfect. Well, Jennifer, thank you. This has been really helpful. It's been great to have you with us tonight, and we really appreciate all the good insight and, very helpful to see the different choices that we have in this process. So thank you for laying those out so clearly. It was very good.
Yeah. Thanks for having me. Appreciate it.
Yeah, well, we're grateful. So, and Pat Butler, it's always good to see you. And Deidre, welcome. Come again. Don't be a stranger. Okay.
All right. Good.
All right. Well, everyone have a great night. All right.
Okay.
Okay,
Thank you.
Perfect.
you.
Thank
You too.
you.
Thanks.
Okay.
Bye-bye.
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 Bye.